the most renowned RN Dash ji, the most prolific speakers, Sri Ashwin Khemka ji, Sri Rakesh Gupta ji, Sri Amit Khemka ji. And I'd like to tell you that today RN Dash sir will be giving an overview on the anti-money laundering law and in India and the role of chartered accountants in handling the same and its interplay with Black Money Act, Benami Law, and Companies Act. And once Dash sir gives the overview, Ashwini sir will take it forward from here. Friends, it is a very great privilege for us that we need to appreciate the sincerity of the learned people like this team, what you're seeing, Rakesh ji and Amit ji. Rakesh ji is coming tomorrow. They also want to give you a brief that what they'll be talking about in the days to come, so that you are also prepared, not only prepared with the subject, but you're also prepared with the questions what you can ask tomorrow. So again, I welcome all of you to this webinar. And before we start, may I request Banu Narayan Rao, our past chairman, Sir Ashwin, remember you was the only person who was wearing the mask in your meeting, signifying the coming of COVID at that on March 4th. So इतना दूरदेश से आदमी को मैं I just request Banu Narayan to give a brief introduction of both Arun Dash Sab and Ashwini sir. Though we introduced Ashwini sir yesterday, a lot of new people are joined and continuously the people are joining. So Banu, over to you for your comments and introduction.
Thank you, Chairman Pankaj. It's my privilege to be a part of today's webinar and also introduce the two stalwarts here. Friends, we have with us an IRS officer who held several high positions and key positions in the government for more than 40 years. He held the position as the director in tax policy discussion of CBDT, and besides serving as the Chief Commissioner of Income Tax, he was the former Director General of International Taxation for India during 2010 and 12. And he was the National Head of International Tax and Transfer Pricing Administration of the country. And during the Vodafone case days, sir was at the helm of the affairs. Am I right, sir? Yes.
Yes, yes, thank you.
Subsequently, from 2012 to 2016, he worked as a member of the country's lone appellate tribunal for prevention of money laundering, adjudicating appeals arising out of orders passed by the Enforcement Directorate. At the time of leaving his job, he was the acting chairperson of the said tribunal. He also worked as a consultant to UNO and the African Development Bank. And presently, friends, he is practicing as an advocate at Delhi and practicing in niche areas as an advisor on the subjects of anti-money laundering, international taxation, transfer pricing, and advanced pricing agreements. Friends, it's my privilege to present to you Dr. Ravi Narayan Das, former IRS officer and today's overviewer. If I am permitted to use that word, he is going to oversee the operations of the day. Welcome, Das Sahab. Friends, and I have the privilege of once again introducing Ashwini Taneja ji. And as our chairman rightly pointed out, when he first addressed us at Hyderabad in the beginning of March, I was wearing a mask and I was asked to introduce Ashwini Saab, and our chairman joked that sir is only taking a precautionary measure and is not infected with COVID. And the words of our chairman have proved very prophetic, and I am still ill and healthy, sir. A cost accountant, a chartered accountant, a company secretary, and a master in law. He practiced as a CA from 1995 to 2007. His expertise was in the areas of auditing, due diligence, tax planning, and litigation, tax litigation, business advisories, and restructuring services. In 2007 to 2015, he practiced as a lawyer in the firm Mrs. RRA Tax India, and focused on the appellate side, practicing before the Income Tax Appellate Tribunal, the High Courts, and the Supreme Court of India, the highest seat of law of the country. In 2015, he was elevated as a member of the ITAT and was posted at Mumbai bench, where he delivered more than 2,000 judgments covering wide areas and wide issues. In 2017, he resigned as a member of ITAT and once again joined the legal profession and is now practicing with the same firm, Mrs. RRA Tax India, and he specializes in income tax and Benami law, and is practicing before the High Court and the Supreme Court and also the tribunals and also the concerned authorities for advanced rulings. A prolific speaker and a paper writer on many topics. He has delivered presentations and lectures in different forums across the country, and he has also published papers on the subjects of his expertise. It is now our proud privilege and the good fortune to listen to Ashwini ji back to back. Yesterday also he was with us, and today also he's going to share his knowledge. And friends, I think we are very lucky to have such a uh, such an intelligent and enlightened, experienced and knowledgeable panelist, and hope we'll have a happy learning. And I request all of you to kindly keep your in mute, keep your microphone in mute mode, so that we can listen to the speakers with all the concentration. Thank you very much, Chairman. Over to you, Chairman.
Yeah. Thank you, Bhanu sir. I'd just like to tell each one of that the entire topic of the 4-day series have been fixed only under the only under the guidance of Sri Ashwin Taneja ji, and he is the person who has brought such excellent speakers to our forum, for which Hyderabad branch is very lucky. And sir, our Central Council member Sri Danyava Sharma has also joined. So before, I think you can just there, sir, you can just say a couple of words before that, and then invite Dasher to give his comments.
Thank you, Pankaj Bhai. And Bhanu, as usual, you are super articulating person. For the entire introduction, I was just getting excited when you were talking about all those, starry words, which is something very interesting always to believe in. First of all, Ashwini ji, again, welcome back today. And yesterday's problem, I think, is resolved today by having little good attendance with us. And I think people are going to join. And the membership number, which I am able to see, is from across the country. Different numbers are there, which are being reported in the chat box. And more importantly, getting Dash Saab it's itself a privilege. A chairman of the PMLA board is not a small thing to really, carry the tag with. And Pankaj Bhai, I think Hyderabad has really fortunate to have such kind of starry people. Apart from that, Rakesh ji is there, Khemka ji is there. All of these people have been in their own world in a different style and different way. And the way what it says is like, the way you walk shows what attitude you carry and what knowledge you have. So if you see the Ashwini ji, the way he has been doing excellent work and the kind of contribution he is giving, and he's taken a lead to ensure that this entire loop is not a one single kadi in the system. He actually completed the entire circle of these laws. If you see the criticality with regards to the economic offenses, this entire I don't think any place a session has happened which is covering all these aspects at one go. I think it is coming as a series for us, and we should be very happy about such kind of opportunity to explore and make it happen. And this is just a start. Fortunately or unfortunately, the period is bad, but I think knowledge doesn't stop once you listen about it, and when you start absorbing, it is retained in mind. When things come into active mode, the situations are totally different. And when you talk about PMLA or might be Benami transactions and other economic offenses, who can be a better person who is a lawyer, who can be a chartered accountant, and we have a combination of a person who has served on the Government of India board, and then we are having people who have been working on with CBDT as well as CCIT, and then again on the ITAT bench, Ashwini ji khud itne sare cases which are rather, I can say you, are very balanced, favorable cases took out, rather than only thinking on one side whether it should be a pro SSE or pro government. He's actually done a fantastic, judgments and the processes in the past. And having such wonderful person again, and tomorrow, day after, again we are going to have. See, Pankaj bhai, the biggest important point in this entire laws is it becomes very critical if it is learnt in a complete sense. It is very important. So I think this session of series of 4 days is going to get the difference for the benefit of our members in a larger way than expected. And Ashwini ji, I can tell you, you are that सूत्रधार. rather मैं आपको बोलूं, आप वो सूत्रधार हैं, वो मोतियों की माला जो होती है, उस मोतियों के माला के आप, you are the thread of that. You could actually get all these 3 people at one go, and you ensure that this हमारे जब गले में, हमारे brains में जब ये knowledge आएगी, it will become something very, very different and interesting. And I think it's a fantastic opportunity for all of us. ICI is also trying our level best. What request I have for our members is, rather than only concentrating on direct tax, indirect tax, statutory audit, internal audits, these are certain areas which are very, very interesting and very, lucrative going forward. The more and more you are getting educated, and the best part about PMLA is, whether it is in India, whether it is in Europe, whether it is in United States of America, PMLA law stands the same. It doesn't change. I have been a speaker on this PMLA on a continuous basis. I have delivered more than 50 lectures across. But only thing which I can tell you is, the beauty about PMLA is, if you see, it is having very few sections, and the section starts with penalties and prosecution. This is something very unique about this particular law, and this law doesn't stand on its own anywhere. Please note down, this law doesn't stand on its own anywhere. This is a dependent law. And when you look at the dependent law, there are a lot to learn and a lot to understand. With this, I can only tell you is, Pankaj bhai, we can start the session. And when having such wonderful galaxy, I would not like to talk more. Thank you very much.
Deva, can I request? Deva, is it okay?
Yeah, I am done.
I'm
done.
audible. Am I audible? Yeah.
Yes, very much.
May I now request Ashwin sir? I think first Dasha will be giving the overview, and then you'll be taking over.
Before that, since we have the benefit of presence of Dr. Rakesh Gupta, who is a powerful and prolific speaker, so some new topic has been articulated especially for Hyderabad branch. So at least let us know what tomorrow he's going to speak, so that whatever queries are there in the mind of our members, so they can draft those queries, send in advance. Let us hear Dr. Saab for few minutes. What is the session for tomorrow? So I think then we can continue with that, if you think it all right. We
Sir,
can invite
you are the boss, sir. अभी हम तो सब आपको follow करना है. Sir Rakesh ji, please, sir. Thank you.
So
thank you.
Before Dr. Saab starts, let me share one important thing. Dr. Gupta, Dr. Rakesh Gupta has been income tax tribunal member and was posted in Hyderabad only here.
Oh.
And today we call him as scientist of income tax. So the new topics, the way he has evolved under income tax, whether it is penalty legislation, whether it is Black Money Act, and few other things about substance over form, GAR, PPT. So, I mean, it will be really a treat to hear him. So over to Dr. Gupta, please.
Thank you, Ashwini, for having spoken so nice words for me. Hyderabad has been a special place in my heart, because I do remember very vividly when I was 37 years old, I saw Hyderabad for the first time as member Income Tax Appellate Tribunal. I having been there for a very brief time for 9 months and then resigned. It was way back 20 years back in the year 2000. Anyway, I learned a lot. during my that stint of 9 months in Hyderabad. So I am the speaker for tomorrow. I do not know why Ashwini ji has said to me, but then the aspects of the penalty under section 270 capital A and 271 double AD, which I am going to cover as to how 270 capital is different from section 270(11)(c. Why was section 270 capital A enacted? Whether the satisfaction recording is still essential for the purpose of initiating and assuming jurisdiction to levy penalty under section 270 capital A. How can the impact of the underreported income be mitigated? How can the concept of underreported income be understood in the simplest manner? Now, what are the insights into the misreporting of income? What are the lapses perhaps have been left unattended by the legislature enacting this penalty provision? And similar are the issues section 271 capital double AD, which is quite harsh and if I term it as draconian. Now, whether that would apply in respect of all accommodation entry transactions or it has got limited applicability. Now, whether it is retrospective or retroactive in nature. Now, whether the rule of double jeopardy. So, I have sent certain questions and aspects on which I will speak tomorrow to Pankaj sir. And I have requested that after the conclusion of this webinar today, he may circulate all those questions and aspects to the members in Hyderabad and other areas so that the members can appreciate as to what will be the comment of discussions tomorrow. Thank you. Thank you. Meeting you tomorrow. I am attending the webinar in any case. Thank you.
The questions received from you will also be placed in the website. And second thing, I'd like to just say that the volume of all the speakers is perfect today. So kindly adjust your volume, sir. Today the clarity is very, God for touch wood. The audio and the video both are good today. So kindly adjust and let only the questions come in question answers so that it helps us to tackle it properly, sir. Thank
yesterday,
you.
Pankaj bhai, yesterday Ashwini ji came and set the pitch right. So now we're playing the game.
Yeah. So, yes, sir. Next, sir. Thank you, Rakesh. Ashwini sir, Amit sir bhi baat karenge abhi.
Yeah, I think Amit ji is here. So what I will tell to the audience that today in the question answer session, because Amit ji is practicing on the criminal side of PMLA. So in the question answers, I think Amit ji benefit will be of great help to all of us. Unless Amit ji wants to say anything to begin with before we begin the session. Amit ji, you want to say hello to the viewers or anything you want to add or at least say hello to the viewers? Khemka ji?
Yeah, sir, you have to unmute.
Unmute.
Yeah. Namaskar, Daya bhai. You just came a little late, so otherwise I had wished everybody else. It is very nice to see your, smiling face always. See the topic which I am going to cover day after tomorrow will of course be the penalties, the prosecutions under all these economic laws. Now, of course, and I have today got a hint from Rakesh ji. I will also prepare those questions and circulate them tomorrow because I have those 24 more hours. So I will also do that. And so that the members can also have questions if they want to ask any, although since chartered accountants don't practice the prosecution on the prosecution side, so therefore there are not many questions whenever I am addressing, but it is very essential for the chartered accountants to understand the interplay and the interconnection of the prosecution with the penalty provisions and also of the prosecutions under the different laws. Because today with sections like 447 of Companies Act being there, almost everything, every little wrong has become a fraudulent wrong and it is not even bailable. The provisions for a grant of bail under the Companies Act in section 447 are very, very severe. So all those provisions one has to keep in mind because these are not isolated. one law is no more isolated in today's world. Everything has cross connections. Everything has repercussions on each other. So we will deal with it. I mean, Ashwini ji has been dealing with it. Today, Ashwini ji will deal with it, and we will again deal with it day after tomorrow. So I will also circulate few of the pointers at least, so that members can have any questions and we can have those questions and I can try to answer them. Thank you very much, Pankaj Bhai.
Thank you. Thank you. Thank you. So, Ashwin sir, may I have your permission to invite
Yes.
sir
Now
for
we are
the
eager.
overview. Right.
We are eager to hear our chairman of the session now. Yes, sir.
Yes.
No. Thank you so much, Pankaj ji, Daya Bhai, and so beautifully he spoke about me, Bhanu Narayan Rao ji. Where from you got this information? When they asked, I wrote only 3 lines and sent it, but you could probably these days from internet you could get something more. And my
one complaint with Bhanu sir is that he always gets an old song. I don't know why he has not done it today. I'm very angry with him, but generally introduces speakers with a song. So I think at least after, once Ashwin sir finished, then I want it from him.
Probably we are more prosaic persons. He forgot about his singing abilities. So, and the other speaker is my young friend Ashwini ji, who is a very charming speaker, all of you know. So I would like to be as brief as possible so that you would get more time to listen to him. So my brush with money laundering law is an accident. See, all along I am a taxman, Indian Revenue Service. I was working long time in the ministry, CBDT, tax policy and budget making. There, way back in the 90s, the drafting of a PMLA Act came to the TPL. One of my colleagues started handling it. So I am one of the persons who came in touch with the subject discussion-wise from late 90s. This act came in 2002. It became effective from 2005. In 1996-97, I never knew that one day I had to deal with it. But that is how the fate and destiny probably were. And when I retired in 2012 from Revenue Service as a DG International Tax, I was made a member in PMLA tribe. Then I had to work there a number of years. So that is how I became linked to this law since its inception till today. And I must tell you that it is one law that is touching the lives of all of us, both as individual and as professional. There is not a day you don't get to know any news about money laundering action, because today in the newspaper it came, ED has brought 108 consignments containing polished diamonds, pearls, jewelries of Nirav Modi and Mehul Choksi, valued at about 1,350 crores, from which was lying in a logistics company godown in Hong Kong. You see, previously it was unthinkable. Under no other law, it is possible, it was possible to locate and make the other country agree, make it, repatriate it so quickly. So, and each of us hears something or other about money laundering. And I'll also tell briefly how as professionals we can be of help to anti-money laundering efforts also. But one thing is clear, all of us must agree that India needs a robust anti-money laundering law, anti-money laundering regime, that is implementation wise also. It will help in the integrity of our financial system, and the existence of a good financial system is something that is in the vested interest of not only individuals, all chartered accountants need that also. So now I'd like to place before you this scenario, how this, and this law is in India is called draconian law. 75, this act is comprises of 75 sections as far as I believe. This and is variously called a draconian law. How it has affected the financial system, legal framework, jurisprudence, and lives of all of us in India, as I told. See, India has been both vulnerable to money laundering and is very combative about fighting it. It is, in terms of anti-money laundering, there is a Basel index. India does not figure very well there. India comes somewhere near Venezuela, in the middle of it, just below Russia. So it is not very complimentary, but not too bad either. When we started FATF, the World Organization for Anti-Money Laundering Efforts, which was created by G7, they gave us a reluctant membership in 2010. 5 years after we had a money laundering law. And then also, they told, after mutual evaluation procedure in 2010, they told us that we will follow up how you are figuring, how you are doing well about your anti-money laundering law. Fortunately for us, we undertook reforms. We removed lots of technical difficulties that was there, both in law and procedure. The Reserve Bank of India took steps to issue master circulars for financial institutions, banks, non-banking financial corporations, chit funds, for everybody practically. And only after that, and in 2010-13, certain amendments to law took place. Indeed, I also recommended something which was accepted. So after that, in 2013, India's followed that. It is under what was removed. India became a full-fledged member. And in mutual evaluation report, this India was considered, though it needs improvement, it is okay as of now. And certain entities which are within the compass of anti-money laundering in other countries are not in India, like chartered accountants in Australia and New Zealand. They are supposed to work as eyes and ears of anti-money laundering efforts and everything. But in India, it is yet to come. So, why I said this, that while we say at the one go that we have a very draconian law, but in the world scenario, even with this draconian law, we do not figure a very bright picture, do not have a bright picture of ourselves, though not a too dismal picture. That is how we stand. When PMLA came, Act of 2002 came, even before that, we had a number of laws, and beautiful laws at that. As Mr. Rakesh Gupta will say, our Income Tax Act of 1961 is a beautifully drafted piece of legislation, which also helped curb money laundering in a way. There was IPC, there was CRPC, there was COFEPOSA, NDPS Act. Later, this Benami Prohibition Act came, Unlawful Activities Prohibition Act was there. All these laws are potent, but there was pressure from the World FATF that those are inadequate and those are not focused to meet the needs of economy and the menace of money laundering, which is a global issue and very particular to India, because huge amounts of money were going away from India in laundering efforts. So this focused law, anti-money laundering law, came for 3 reasons. First, to combat and control money laundering. Then second, to seize and confiscate the property from laundered money, and also to deal with any ancillary issues that may come up with money laundering. India has taken steps to implement an effective anti-money laundering regime. See, for this, that we have a legal framework, that is the Prevention of Money Laundering Act. This is 2002, a small act, but I must say it is poorly drafted, not as well as our Income Tax Act. Then setting up a financial FIU, Financial Intelligence Unit, that does the cooperation worldwide and also collects all the information, disseminates all the information. Then having an enforcement mechanism in Enforcement Directorate. All major wealth creation firms, whether banks, non-banking financial companies, intermediaries like stock exchange, brokers, venture capitalists, portfolio managers, credit rating agencies, financial institutions, investment advisors come under the spectrum of money laundering as reporting agencies. They have to send reports of suspicious transactions. They have to send reports of a cash transaction after certain threshold. They have to really do the KYC in respect of the customers. They have to go beyond the facade to find out who is the beneficial owner of any particular asset. But with this law, there is still room for further improvement. First, as I said, in the area of legislation, there is scope for improvement. The poor drafting, which were tinkered with many amendments, need to be consolidated, and the law being new, the jurisprudence has not developed, judgment laws have not come. Many issues require to be decided at the level of high courts, Supreme Courts. So we are not, our money laundering law is not as mature as in UK or USA. Then the regulation of a traditional money or value transfer services to facilitate expansion of new payment products need to be expanded. It has been done quite a bit under the Modi regime, but this will help shrink the informal network of a cash transaction. The last but the most important thing in improvement is its implementation. This implementation is done by Enforcement Directorate, as all of you know, and Enforcement Directorate, as you know, it's I have the statistics to show, which probably Mr. Taneja will show in a table or something later on if that is required in his this thing. But basically, what it's the statistics show that despite all the noise that it is making, so far the number of prosecution complaints filed till end of 2018, for which statistics is available in public domain, is only 451. What they do the best is that they attach the property and get that attachment confirmed by what many people complain as a compliant adjudicating authority, and be satisfied with that as their achievement. And the convictions so far, the Minister of State for Finance in October 2019 told in the Parliament that there are 13 convictions ever since the law came in 2005 till October 2019. And I have collected subsequently that 7 convictions have taken place of one family of Jharkhand, Hari Narayan Rai case, the gentleman and all his family members. So total one score of only convictions have resulted since 2005-2020. And then again, more than 50% of all attachments, if you will go, you will find those are bank loan cases. Bank loan cases are interesting. Not all bank loan cases are bank frauds. But when a loan becomes unrealizable, and there are some little issue for which an FIR can be filed, the banker, in order to save their skin, they do that. Once they do that, it becomes easy for ED to exercise jurisdiction. So more than 50% of all the attachments, volume-wise, asset-wise, value-wise, is from this source. And more than 20% is for corruption cases. And mind you, we had already effective laws to deal with bank issues, bank loan issues, and corruption issues, and potent laws at that. So it is becoming a parallel. Of course, with this law, they can move fast and do it easily. And besides this, there is also allegations that ED has become a competing agency to CBI income tax due to the manner in which money laundering offense is defined, and they come into the fray almost as quickly as these primary investigating agencies start the business. Another allegation about ED is that sometimes it is more or less, it helps the government of the day and is not as impartial as it should be. So ED should also develop internal protocols, and its work needs to be audited by an appropriate independent regulatory authority. Insofar as professionals, CAs are concerned, you have vast experience in handling huge quantitative data and all these things. So it will be easy for you to address many issues of anti-money laundering. I have seen from the bench that chartered accountant lawyers have been more effective in presenting the money trail than the pure criminal lawyers. So now I have given an overview of the law as it is being implemented. It's our standing in anti-money laundering efforts in the world, and now to have the nitty-gritties of the law and how it interacts with the corresponding laws, Mr. Ashwini Taneja will explain to you in a more charming manner. Thank you very much.
Thank you very much, Raj sir. Without wasting much time, thank you, and it was an excellent presentation. But without wasting much time, I request Ashwini sir to take over, please.
Thank you very much. Firstly, I must say my gratitude from the core of my heart for organizing this seminar and for inviting me to discussion on this topic, which is also very, one of the favorite topics of mine, particularly in today's regime, when all of you must be aware of that all the departments are put in deactivated mode, except one department, that is PMLA department. So when we got circular from Honorable Finance Minister, Mrs. Nirmala Sitharaman, that dates have been extended, you would have said in that ordinance in circular that dates have been extended for Benami law or income tax only, but not for PMLA. So believe me, PMLA department has been working completely, even at the time of lockdown. And that is why you got to read the news that now today this property has been attached and this property has been attached, etc., etc. So friends, first of all, Daya bhai, thank you for organizing this seminar, and Pankaj ji, thank you for taking the pains, and Bhanu Saab, thank you for kind words, and my respected co-speakers of the day and for the in the coming days, Honorable Shri R.N. Dash, Dr. Rakesh Gupta, Shri Amit Khemka ji, thank you for joining and making this session a good session. And I can see we have people from abroad also, Sanjay Pawarji from Singapore chapter and many more. And brothers and sisters, thank you for joining. Now this money laundering, the moment this topic money laundering comes to our mind, the first question is, what is this money laundering? Is it converting black to white? That is money laundering. It immediately comes to our mind. So is it so, or something more is there? In fact, just converting black to white is, using an untaxed money into mainstream. For that, we have income tax law to take care of that. So that means money laundering is something more than that, because if income tax department, income tax law is already created for taking care of that situation, so that means there would be something more which is not being taken care by that. So that is why probably we have got some more law, that is money laundering. So what is then money laundering? That is, we will understand what is money laundering. But before that, let me go step by step. This aspect of money laundering, why we have chosen this topic to be shared with our chartered accountant brothers, because apart from many reasons, one of the reasons is that now there has to be going to be strong interplay between the income tax law, money laundering, Benami law and money laundering, and various laws. So having knowledge of only one law and then guiding a client may not be a wholesome exercise, may not be a holistic approach. So we have to have, even if we may not be intending to do practice in all the areas, we need to have some little bit of knowledge of, this money laundering and Benami law also, so that a holistic guidance could be given to our clients. Particularly when one law is affecting the other law in a very intense manner. Not only that, the agencies are going to work in a highly coordinated fashion, in tandem. And the spectrum of the anti-money laundering law department, that is ED, is going to be quite wide. So I will show all those things, how this spectrum is going to be wide. The connect of this law, spectrum of this law is also quite wide, far wider than what we think and imagine. That is what I will show to all of you. But if you could kindly allow me share screen. Yes, it has been allowed. So I will be going with the help of my PPTs so that we do not feel any inconvenience in understanding what I am trying to share with you. So friends, if you will kindly see, I will be taking up today the practical aspects of money laundering only, so that it becomes more convenient for all of us to share my thoughts with you. So I hope my slides are open before you. So first slide which I have brought before you to show this picture. This chimpanzees. This was a news published in Hindustan Times. I was amused to read, and I hope you must have also been amused to read whenever you have read this newspaper, that chimpanzees were attached by Enforcement Directorate. So I thought, chimpanzees attached by Enforcement Directorate? I mean, how it is possible? So that is why I was saying, my dear friends, that the connect of the idea is going to be too wide. When I analyzed the logic behind it, I found that ED can make attachment of proceeds of crime. I will explain what is proceeds of crime. So crime, proceeds which are derived from any commission of any crime. So one offense was committed, that is violation of Wildlife Protection Act, and some forgery was committed to taking custody of these chimpanzees by the person who was having their custody. So two laws were violated, and that is why scheduled offense was committed, and chimpanzees became the proceeds of crime. And since proceeds of crime can be attached by ED under Section 5 of PMLA, that is how these chimpanzees were attached. They were thankfully handed over to the zoo authorities for their proper upkeep. But this is such a wide connect is there of ED. Then you would have read this news also, that Modi's Benami law has companies running for cover, and many other things attached to that. Then CBI ED action may now follow IT default probes and multi-agency scrutiny. The three agencies are coordinating among themselves, as well as using the power of higher order data analytics. So using the technology of data analytics, the agencies are going to work in hand with each other. So on the one hand, we are going to have a practical scenario where the agencies are working in synchronization with each other. On the other hand, the laws which have been drafted, that is the legal system, is going to be such that the law will be having an interplay with each other, mutually connected laws. So legal system is connected, the agency framework, the investigation, the enforcement framework is also connected. So, I mean, there is going to be hugely strong interplay between various laws in times to come. Then, sir, offense of money laundering. So there is something more than just evasion of tax, as I shared. So in common parlance, what we understand is there has to be some commission of offense. before we can talk about money laundering. So somebody has to commit an offense, and that for offense, from that offense, the person who has committed the offense should earn some proceeds, and the proceeds so earned should be portrayed as the proceeds as if these are not the proceeds from any commission of offense. Rather, these are proceeds from some legitimate activity. So legitimizing the illegal proceeds is money laundering in broad sense, in common sense. Though there are some ifs and buts under legal understanding, but this is, as a commoner, I would say this is how we can understand it. And all over the world also, this is a common understanding, the way people understand it. So there has to be legal dirty money. It's converted into legitimate and white money. And these have been the few popular activities to carry on the job of money laundering. Then what is the law which deals with this kind of activity here in country, this kind of offense? It is principal legislation is Prevention of Money Laundering Act 2002. As Dash Saab has said, in 2002 it was enacted an act, but with effect from July 2015, July 2005. And then we have the agencies, the enforcement agencies is Enforcement Directorate, and that has got the executive functions like act of enforcement, inquiry, investigation, search, seizure, and making provisional attachment of the properties. Then ED has also been given power of arrest. Then it can initiate prosecution, etc. And all these functions are performed by the authorized officers under this act. Then we have other prominent authority, that is adjudicating authority. Now, this is an authority which has been constituted under PMLA, and it sits at Delhi. It is only one bench at Jeevandeep Building, Connaught Place. So after the matters are concluded by the Enforcement Directorate, then its adjudication is done by the adjudicating authority. For example, examining the attachment orders, provisional attachment orders, PAOs, passed by the Enforcement Directorate. Presently, it consists of a chairman and two other members, and one of the members is member law, other member is member in the field of finance. And the member finance is from Income Tax Department, former IRS officer, that is former Chief Commissioner of Income Tax. Then we have appellate tribunal. After the orders are passed by the adjudicating authority, then the matter goes to the appellate tribunal. The appellate tribunal, whose chairman has been Mr. R.N. Dash before Mr. Honorable Justice Manmohan Singh was heading that tribunal. And it is having principal and the only bench at Delhi at Lok Nayak Bhavan, 4th floor. And today it is surviving by one member because of retirement of other members and Honorable Justice Manmohan Singh. So it is Mr. G.C. Mishra is the current head. So after the orders are passed by the adjudicating authority, the appeal is filed to the appellate tribunal within 45 days. And then tribunal is, does the hearing like Income Tax Tribunal does the hearing. So it is different from Income Tax Tribunal. It comes under Ministry of Finance, and whereas the Income Tax Tribunal comes under Ministry of Law and Justice. So that is also another distinction, because of which we find that sometimes the orders are not as detailed and as independent, as well reasoned as we get in the case of orders which we get for Income Tax Appellate Tribunal. Then this is very, very important, another agency, that is special court. So the ED can make attachment of the properties, and these matters are redressed before the adjudicating authority and appellate tribunal. On the other hand, simultaneously, ED can also make prosecution complaint. That is, the ED can require the court to prosecute a person. And this is also a topic in itself, which will be taken up by Shri Amit Khemka ji. I think tomorrow is the day for that. So simultaneously, it can also take up the prosecution proceedings, and which are done by the Court of Sessions of the city. And it is called Court of Session, Special Court. In fact, the High Courts have designated special courts for this purpose. That is why we call it a special court. In every city, probably one court has been designated for this purpose, who will take care of the cases of income tax, prosecution cases of income tax, anti-money laundering law, and Benami law, etc. Then, why ED's actions are said to be too harsh, or why this law is said to be too harsh, because of this reason also, that simultaneously many actions come into motion. Like the moment any ED complaint is filed or ED takes into action, simultaneously many actions are taken. I have tried to summarize those actions, and I am saying that these are the web of actions which are taken by ED the moment ball is put into rolling. Like suppose any investigation or search, etc., is done by any income tax department, police department, CBI, NCB, Forest Department, or any other agency. And if it is found by that agency that there are certain things which are tantamounting to offense of money laundering, some actions by that person whose search has been done, or suppose some ED gets some complaint in this regard, then ED starts an investigation. And ED starts investigation into two directions simultaneously. So it can attach the properties which are proceeds of crime, and it can also file complaint to the court, that is prosecution complaint, we call it as popularly, to the special court. So two actions simultaneously it takes. And on the other hand, since the person has committed some offense, scheduled offense, on the basis of which this kind of offenses are alleged, offense of money laundering, so that activity also goes on, that proceeding also goes on. So three proceedings simultaneously go. One is of scheduled offense, other is prosecution complaint by the ED, and third is attachment proceedings by the ED. So then ultimately executing authority decides about the attachment proceedings. Then if it confirms the provisional attachment, then appellate tribunal decides what will happen. On the other hand, special court decides whether in the criminal trial person will be convicted for scheduled offense and will also be convicted for the offense of money laundering, and then ultimately his property will be confiscated or not. So that is how in nutshell, the many activities initiated by the enforcement directorate take place. Then this definition part, which we have understood in common sense, I will try to be a little more legal in terms of its explanation and clarity. First of all, money laundering, how the law decides the aspect of money laundering. The PMLA defines the offense of money laundering under section 3 as whosoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming as untainted property shall be guilty of offense of money laundering. Now, friends, kindly see. Firstly, the definition has been given, in a wholesome manner kind of thing. Many things have been attempted to be included there. Then second thing, I have put the word "and" in red color. So meaning thereby, as we commonly understand, the activity says, the definition says, the concept of money laundering says that there has to be commission of offense, and then the person has derived proceeds of crime, and it should convert the proceeds of crime into as if it is from clean money, that is untainted money. So I have put this word "and" in red color just to convey some thought that this word "and" has been tried to be shaken in recent amendment done in the law with effect from 1st August 2019. So, I mean, what kind of ultimately situation will arise, what kind of law they have brought out now, that we will definitely discuss. But this word "and" has been given because it is creating some kind of confusion now because of the amendment. That also I will discuss very shortly. Then one explanation has been added with effect from 1st August 2019, which says a person shall be guilty of offense of money laundering if such person is found to have directly or indirectly attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more process of the following process or activities connected with the proceeds of crime, namely concealment or possession or acquisition or use or projecting as untainted property or claiming as untainted property in any manner whatsoever. So confusion is rising now. Instead of word "or" has been placed. We will discuss it in detail little after a short while once I'm clear with some more definitions with you, because I have kept this topic for specific discussion in my slides. Then, sir, what is proceeds of crime? You must be thinking that I have said that a person earns the property from crime or derives some proceeds. So what do we mean by proceeds of crime? Section 2(1)(u) defines the proceeds of crime. It says proceeds of crime means any property derived or obtained directly or indirectly any person as a result of criminal activity relating to scheduled offense, or the value of any such property, or where the property is taken or held outside the country, then the proceeds equivalent in value held within the country or abroad. So it talks about two situations: where the property is held in India, then what will be the proceeds of crime, and when the property is taken outside India. So it says value of any such property. So value means it should be that very property which is derived from proceeds of crime, or any other property. If that property is not available, that property can also be attached. So what is the precise intention, scope, definition, interpretation, understanding of law in this regard? So this also let us understand. First, let us cover the basic parts of it. And when the property is taken abroad, then what would it mean? Then also the equivalent part can be covered, or only that very property can only be covered? So this is a very, very controversial issue which has become today, and we will definitely discuss it in detail. So one new amendment has been made out with effect from 1st August 2019. It says, for the removal of doubt, it is hereby clarified that the proceeds of crime include the property not only derived or obtained from the scheduled offense, but also any property which directly or indirectly be derived or obtained as a result of any criminal activity relatable to scheduled offense. So second thing which they are trying to cover is that they will also include, suppose one offense has been committed by a person, but that offense is not scheduled offense. We will understand what is scheduled offense and what is not. So if not scheduled offense, it may not be covered under PMLA, but some other offense has been committed. So sorry, what I'm trying to say, suppose a person commits scheduled offense, but from there, it does not earn any proceeds of crime, but it commits some other offense, which is though not scheduled offense, but from there proceeds are earned. So then the amended law says, if even ancillary law has been committed, ancillary offense has been committed, which may not be scheduled offense, but ancillary to the scheduled offense, and scheduled offense, then that will also be covered within the definition of proceeds of crime. Any proceeds earned from ancillary scheduled offense. So meaning thereby any proceeds earned from an offense which is not a scheduled offense but is ancillary to scheduled offense, then proceeds derived from such ancillary act will be covered within the definition of proceeds of crime. Then what is scheduled offense now? Scheduled offenses are the offenses as prescribed in Schedule to the PMLA, which is in 3 parts, that is part A, B, C. So friends, what the legislature has done is that they have given a list of the offenses, that if this kind of offense is committed, then and any proceeds are derived therefrom, then it can be included in the offense of money laundering, subject to other fulfillment of other condition, of course. So what are those offenses? What are the list? In fact, the list have been given appended to PMLA, and it is a list is very, very long. Though the entire purpose of bringing out this legislation was to take care of those offenses which are of very, very serious nature, which are attacking the financial integrity and sovereignty of the country, such as drug peddling, such as terrorism, such as dealing in arms and ammunition, such as corruption. And that is how on the recommendation of the United Nations, when the resolutions were passed at United Nations, Financial Action Task Force was constituted, as was rightly put by Honorable Shri Dash. And then resolution, but in pursuance to the resolution and FATF recommendation, the law was made. First bill came up in 1998, when it took the shape in 2002, which was enforced from 2005. And the whole purpose was to bring ourselves in line with the international requirement, the global requirement to tackle the menace of money laundering, which was prevalent all over the globe. And the initial idea was to take care of the heinous crimes, the serious crimes. But the way list has been made, every kind of theft, dacoity, forgery, 420, 120B, many kind of legislation, even now violation under Black Money Act, that has also been included there. Certain violation of certain sections of Customs Act have also been made there. But violation of income tax law as such has not been made. That is, tax evasion has not been made as part of scheduled offense. This is a very, very widely prevalent and frequently asked question. So answer to that is that tax evasion has not been made part of scheduled offense, my dear friends. But Amit Khemkaji would explain it at great length, that though it is not been made part directly, but indirectly it can be covered in such manner that if a person to do tax evasion does some other offenses, for example, it does forgery with the documents, it does some cheating, it does some other conspiracy, which are punishable under some sections of IPC, and those sections have been covered as part of scheduled offenses, then going by that route, that kind of offenses can be covered as part of scheduled offense and consequently under the offense of money laundering. So this list also includes the names such as Wildlife Protection Act, Water Pollution Control Act, Air Pollution Control Act, etc., etc. Then this whole exercise of money laundering can be broadly divided into 3 stages. Stage 1 would be commission of the scheduled offense. Stage 2 would be generation of the proceeds of crime. And then stage 3 would be commission of money laundering by the placement layering integration. So first crime is committed, proceeds are generated, and then these are mixed into the clean system. And that is how I have portrayed it with the help of another slide, which you can take a look till I sip water. So friends, in fact, common understanding is that these are very, very essential ingredients and steps towards process of money laundering. Commencement of the proceedings under PMLA. Now, basically, now we understand what is money laundering, what is proceeds of crime, what is scheduled offense, and who is the enforcement agency, enforcement directorate. Now, how the proceedings are commenced. So proceedings are commenced whenever the ED receives any complaint or information from any sources that this person has committed scheduled offense and also the offense under money laundering. Then it can set up inquiry and investigation by conducting like issuing summons under section 50, by making discrete inquiries in any manner. Under section 50 empowers the authorized officer under ED to summon a person, and the powers given under section 50 are akin to the powers which are given under civil procedure code to a court to summon the witness and to carry out the inquiries and to take the evidences. Then apart from that, the ED has also been given the power to do survey and search and seizure under section 16 and 17 of PMLA. Then friends, how the proceedings are initiated. So suppose some search or survey is conducted. So if some documents are impounded, so the documents can be retained by the enforcement directorate, and the period of retention is though 15 days, but it can be extended if the ED files the application, original application, that is called OA, under section 17(4) of PMLA before the adjudicating authority. And then when ED makes attachment of the properties under section 5, because section 5 gives power to the enforcement directorate to make attachment of the properties which are derived from proceeds of crime to prevent its transfer, its alienation by the person concerned, and with a view to have such kind of protection, the powers have been given under section 5 of PMLA to authorizing the officers to make attachment by after following due process of law. So immediately thereafter, the ED they are required to they are required to file original complaint under section 5 to the adjudicating authority, and the adjudicating authority will thereafter do hearing on the original application or the original complaint, that whether the action taken by the enforcement directorate is in accordance with law or not. So if they find it in accordance with law, then they can confirm or allow the original application or original complaint filed by the enforcement directorate. Of course, after giving opportunity to the other party, that is affected parties. So if the applications are allowed, then their provisional attachment order is in a way continued or confirmed. Similarly, original application, then the documents can be retained. And if it is not confirmed, then these are to be released by the enforcement directorate. Then, as I shared earlier also, then apart from attachment of properties, it can also file prosecution complaint before the Court of Sessions under section 45, which initiates and gives rise to the initiation of criminal trial of the person accused of offense of money laundering. Then this OA thing we can skip for the time being. This I have already covered. The OC has also I have already covered. Then now let me take up some of the important issues which we face. So first issue is that what are proceeds of crime? So friends, as I shared with you, that proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to scheduled offense, or the value of any such property, or the value of any such property is taken or held outside India, then the property equivalent in the value held within the country or abroad. Now, the issue which arises here for our consideration is that suppose I will try to explain you with the help of an example. Suppose a person did some theft. Say it stole around 10 lakh of rupees, and the money so stolen was deposited in the bank account. and from the bank account, it purchased gold. It sold the gold and deposited the money back again in the bank account and purchased shares. And the shares value became 50 lakh rupees. And then it bought plot of land, say of rupees 50 lakh, and added another 25 lakh. So total plot value was 75 lakh rupees. So what can be added? What can be treated as proceeds of crime here? I think the answer would be that anything up to the plot of land and where the value increases from 50 to 75, where the 25 lakh another was added from some other source. So up to the value of rupees 50 lakh, the property can be treated as property derived from proceeds of crime or value of such property. But the question arises, suppose the person loses the money, the entire 10 lakh rupees he had stolen, then he goes to the casino or loses the money. Then whether ED to recover this 10 lakh rupees can make attachment of any other property? And this is the big question. Now there is a difference in the law as per books and the difference as per law as per practice. Because as per practice, they will attach any other property also. But as per books, my understanding, considered understanding with respectful opinion is that it covers only the first situation. That is, the property to be attached should have trace back to the crime, to the offense. And if it has no trace back, it is clean property, it cannot be attached. Now, to give clear interpretation of the law, I have bifurcated this section into two parts. If you see, there are two situations which have been envisaged under the law. First situation says when the property is held in India, that is proceeds of crime means any property derived or obtained directly, indirectly by any person as a result of criminal activity relating to scheduled offense or the value of any such property, right? If the property is in India, then this is the definition. Now, second situation is where the property is taken or held abroad. For example, property is derived from here, India, but taken or held abroad. Then it says the proceeds of crime would mean property, etc., and then the property equivalent in value. So kindly see, in earlier first situation, the legislature is using the expression value of any such property. Whereas in second situation only, it is using the expression property equivalent in value. And this amendment was done later on. If the legislature was of the opinion or that the intention of the law is to cover equivalent in the first situation also, there was no need for the legislature to create second situation and cover the second equivalent word here also. So that means the legislature has made clear demarcations between the two situations. So in the first situation, where the property is held in India, only that property which is derived from proceeds of crime can be attached. Whereas in second situation, only property equivalent in value, meaning thereby any other property can be covered. Now to give you another example, here, for example, as I said, in the case where the property is lost, so no other property can be attached. Yes, the prosecution of that person can take place because if he has done the offense of money laundering, that can take place. But property which can be attached it should be proceeds of crime only. Now I explain this entire concept with the help of an example. Suppose you observe an ant. You pick up the ant, dip it in ink and leave it back. And if the ant is still alive, then it will move. And wherever it will move, it will leave a trail of the ink, some line it will leave. So similarly here, the proceeds of crime are also like that. Wherever the property is moving, it should have that trail only. And under that trail only, the attachment can be done, not beyond that. So we will take up more examples in slides to come. But before that, I will give one other reasoning why this property only which is derived from proceeds of crime can be covered. One other logic I will give. The other logic is the property ultimately is to be confiscated. The attachment is being done only for the purpose so that when the special court orders for the confiscation of the property is available before the court. And if the court will order for the confiscation only when the property is found involved in the offense of money laundering. If not found involved in the money laundering, then the special court, as per law, is duty bound to order for its release. So if the property, some other properties which is not involved in the offense of money laundering, then what is the fun for making attachment of such property? Ultimately, court will have to release it. What for? So this entire reasoning it was put before us in the tribunal, before the tribunal in one case, and ultimately one of the matters reached before the Honorable High Court of Punjab and Haryana, and in a judgment which is beautifully drafted, well-reasoned judgment in the case of Seema Garg and others versus Directorate of Enforcement. The date of the judgment is 6 March 2020, number PMLA 1 to 3 of 2019, wherein on this reasoning, Honorable High Court has said that yes, the property should have trace to the proceeds of crime. No independent property can be covered within the definition of proceeds of crime. So wherever ED is taking some action, such kind of action that is illegal, very harsh. Then Satyam Computers case from Honorable Andhra Pradesh High Court. I think some of the members would have read this judgment. They have also said that yes, only proceeds of crime means the property which is covered in the proceeds of crime and no independent property. And this Satyam Computers judgment has been followed by Seema Garg. And then one other judgment from Delhi High Court, Abdullah Ali Balsharaf judgment has also been followed by Seema Garg. But there is one contrary judgment in which contrary view has been taken by Honorable Delhi High Court, single member judgment, that is Department of Enforcement versus Axis Bank, Honorable Justice Gaba. Their judgment has not been followed by Honorable Punjab and Haryana High Court in the Seema Garg. So that is how the present scenario, the entire position existing in the country has been summarized in this slide, that how proceeds of crime is to be computed, etc. Then friends, with regard to section 3, as I said, that section 3 says, defines the offense of money laundering, whereas section 24 lays down the burden of proof to be discharged. I will specifically deal with section 24 because section 24 makes a mention about the reverse burden concept, reverse burden of proof kind of concept. We will deal it later, but let us focus on section 3. So there is little controversy and distinction in the law as per books and law as per practice. Also, some confusion is being attempted to be made by the new amendment. As I said, that the basic concept of the offense of money laundering is that there has to be 3 stages involved. That is, first of all, there has to be, the commission of offense, then earning of proceeds of crime, and then from proceeds of crime should be converted into the proceeds as if they are not from crime, but from some other legit activity. For example, a person does smuggling, earns therefrom, but shows it as income from consultancy. That is what is offense of money laundering is. But friends, because of this confusion, that is word and, because of this and was there earlier. Now, because of this explanation which is using the word or, some people are interpreting it in some manner that that as if the conversion from bad money to good money is not essential. The moment bad money is earned, it is offense of money laundering. So if that is the interpretation, the whole concept of offense of money laundering will vanish. The moment a person, for example, the moment a person does theft and steals money, then that itself will be offense of money laundering. So he will be punishable for the theft and for offense of money laundering for the same very offense. That cannot be the intention. So it has become a gray area as on date though, but I am hope courts will properly understand, courts will read it properly, and if necessary, read it down our constitutional courts, that is Honorable High Court or Honorable Supreme Court. And till then, let's wait and try to understand the law in the right perspective. Then friends, the whole controversy which is arising under PMLA is because of misunderstanding of the concept of burden of proof, which is explained under section 24. As we all know that that our constitution is based on the fundamental concept that a person is innocent unless proved guilty. And the burden to prove guilty is upon the person who is alleging, that is prosecution. But it is also said under PMLA law, this concept has been reversed. So that is why we say there is a reverse burden of proof kind of concept here. But friends, the irony is that the reverse burden is not wholesome, absolute. It is only part of the burden which is reversed. There are 3 stages. One is scheduled offense has been committed. Other is commission of proceeds of crime has been earned. And the third is that crime, so the proceeds so earned has been converted into good money. So if I read section 24 clearly, the answer would come, the interpretation would come that the burden has been shifted only for 3rd stage. That is converting of proceeds of crime from bad to good, not for earliest 2 stages. Whether a person has done a crime, the burden has to be upon the person who is alleging, that is a prosecution. Now I will read the section before you. In case of person charged with the offense of money laundering, the authority or the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. So presumption is only for a proceeds to have been earned under the proceeds of crime. So there has to be evidence that there were a crime and proceeds were earned. Only then the reverse burden of proof concept will come into play. Then, sir, under section 5, there are pretty good provisions which envisage that the reason to believe should be made by an authority, that why the authority thinks that the assets are likely to be alienated, but reasons are not recorded properly sometimes, and ditto language of the section is reproduced ditto in the reasons. And Honorable Punjab and Haryana High Court, in the case of Seema Garg, has said that this kind of reasons are not good reasons, and therefore they have quashed such kind of things. Similarly, adjudicating authority, when it has to hear the parties, then it has to issue notice. Then the duty is upon the adjudicating authority also to record the reasons before inviting the parties or giving show cause notice, that why this offense of this should not be, the property should not be attached, and the provisional attachment order passed by the enforcement directorate should not be upheld. But before issuing the show cause notice to the party, it has to record the reason that why this so and so party should be made defendant, why it should be asked to appear in before the adjudicating authority. But there also a mechanical notice is issued, and there is no concept of recording of reasons. And that is why, since due process of law is not being followed, that is why this law as on date has become quite harsh. And then, friends, I will deal with this interplay which I had left yesterday open. So today we will be taking up queries on PMLA also, under Benami law also, as was promised that if certain queries were left yesterday, we will be taking up today. So before that, interplay with regard to income tax law and Benami law we understood yesterday. Now today, let us understand the interplay between anti-money laundering law and other laws. Sir, the provisions of PMLA law clearly says that this law is in addition to, the provisions of this law is in addition to and not in derogation of any other law. Number one. Number two, whenever a person does any violation under any law, it may be possible that he has simultaneously done any scheduled offense also. And if it is done, then the chances are that he has done the offense of money laundering also. So, for example, if a person is doing tax evasion, so mere tax evasion is not, will not constitute the offense of money laundering itself. But if he has done some offense and then he has, in doing that offense, he has evaded tax, and then by evasion of tax, he has converted the money into some other form, then there may be chances that he has then done the offense of money laundering as well as tax evasion and then scheduled offense also. For example, a person does some smuggling and say he earns rupees 10 crores, and out of the 10 crore rupees so earned, he shows in his income tax return as income from consultancy 2 crores, and out of rupees 8 crores, suppose he out of rupees 8 crores, 3 crores is sent abroad to be stashed in his undisclosed bank account, and out the remaining 5 crore he gives to one B Limited, and B Limited in return gives back share capital to R Limited, in which the person who has done smuggling, say his name is R. So suppose R has given cash to B Limited, and B Limited gives back the check to R's company, namely R Limited, as share capital, and R Limited gives back, issues share certificates to B Limited. Then let us envisage let us visualize and evaluate how many laws have been evaluated. First of all, Customs Act have been evaluated because of smuggling. Then FEMA, because he is sending the money abroad out of Hawala. Then Black Money Act, because he is stashing the money abroad, 3 crore rupees. Then income tax violation, because he has suppressed the proceeds and income, he is showing only 2 crores, 8 crore he is suppressing. Then he has committed the offense of Benami law, because shares held by B Limited are Benami. And then he has done the offense of money laundering, this 8 crore rupees, which is earned from smuggling, which is a scheduled offense. Now it is entire money is subject to action by the ED authority. So that is how these laws are having interplay with each other. Then 1 or 2 case studies I will put before you. So these case studies will show that how wide the spectrum of ED has become today. One factory was set up, distillery unit, way back in 2005, and there was some allegations subsequently that it has done violation of Water Pollution Act because of discharging extra water into the river. So subsequently it made some corrections. It set up a plant, water treatment plant. Then therefore no action was taken by Pollution Control Board. So merely FIR was filed and no action was taken thereafter. But suddenly ED, after some years in 2018 or so, issued notice for attachment of its factory. So I thought on the ground that Water Pollution Act was violated by you. So I thought how Water Pollution Act violation and ED comes into action and how factory attachment, because they wanted to take possession of the factory, being pursuits of crime. I thought how it is possible. When I understood the law, I understood the case properly. So reasoning given was something like this. Then the factory was entitled and authorized and licensed to say manufacture say 50,000 kiloliters, 50,000 liters of say spirit, but it discharge extra water equivalent to 75,000 kiloliters. So then since it discharged extra water into river. So that means it had made extra production. So since it made extra production, so that means it earned extra sales. That means it extra profit. So extra profit is by commission of offense, that is Water Pollution Act violation, Water Pollution Control Act violation, which is a scheduled offense to the under the PMLA. And since scheduled offense has been committed, and extra profit earned by the factories because of commission of that offense, and extra earned so profit has been invested into factory, and that is how factory came to be attached. So we become successful in getting status quo somehow from the Honorable Tribunal, where justice is granted in the deserving cases. So, but that is how the people have come into trouble. So friends, next case study, a gentleman wanted to do, trading investment in Bitcoins, which was not an offense at that time, though subsequently it was made offense. But in the meanwhile, what had happened, the company through which it was dealing, probably it made some defaults, and various FIRs all over the country was filed. And because of the proximity of the investor with the management, he was also considered as part of the company. And ultimately, this dealing in Bitcoin has been treated as scheduled offense, as because of some charges like forgery and all that. And though the investment which is made in Bitcoins is lying in Bitcoins, but his fixed deposit receipts, FDRs, lying in the bank account has been attached as pursuits of crime, without showing even the nexus between the Bitcoin, the earning therefrom, and the deposit made into fixed deposit account. So friends, now lastly, why we have gathered here, to understand the role of chartered accountants and tax lawyers in handling the notices and attachment orders issued by the ED. Friends, in fact, this is such a fabulous law that none of the professional is complete in themselves, whether he is a lawyer or a chartered accountant. And because this has got elements of both, because we have to compute pursuits of crime, and since we compute pursuits of crime, it is the chartered accountants only who can understand the pursuits of crime. And chartered accountant cannot themselves do it all alone, because it involves understanding the law and raising it before the adjudging authorities, and also representing in the criminal trial. So in fact, it requires to some extent useful input from the chartered accountant, and the criminal lawyer can take it up further thereafter. But the role of the chartered accountants cannot be undermined, and a very, very useful role. But because the chartered accountants do not perform the role, only lawyers compute the pursuits of crime, it becomes an inaccurate exercise. And then sometimes the orders are passed only on guesswork basis. And that is how the injustice is done to certain parties. Now, I will explain with the help of a suitable example, which is, very, what should I say, a maximum number of cases are arising on account of such kind of situations. Now, for example, a corporate has obtained a loan from a banker. Let us take example of a big corporate client of the borrower of the banker, say 1,000 crore ticket size loan was obtained from a banker. But suppose default was committed in repayment of the loan. Banker later on find out some forged documents were presented, and loan was obtained by the borrower by fraudulent means, and there was siphoning of funds also thereafter. So section 120B, section 420, etc. was invoked, and complaint was filed, FIR was filed, and then complaint was filed by the ED. ED swings into action, files a prosecution complaint, makes attachment of the properties of the company, and then that is how the case comes before us. Now here, what will be attached? Attachment should be of pursuits of crime. Now what will be pursuits of crime? Now, pursuits of crime will be that 1,000 crore rupees loan taken by the borrower from the banker, and that will not be available in the same shape, because that 1,000 crore may have traveled all along into various channels. So wherever, with whomsoever this corporate may have dealt, so wherever, that you remember that recapitulate that ant example. So ant dipped into ink. So wherever that is moving, so that is pursuits of crime are also moving in that direction. So friends, I mean, very strange situation arises that how would you compute? There arises a role of chartered accountants in understanding and helping the client. So I have listed out how it can be, done by the chartered accountant in discharging that role. For example, identifying the sources of the attached properties and differentiating it with the alleged pursuits of crime, identifying loan utilization in the attached property, calculation of the correct value of alleged POC, valuation of the property attached and comparison with alleged pursuits of crime, then proper financial accounting and analysis, preparation of money trail for the attached properties to demarcate the source of fund. Friends, in this example which I have taken, a very strange situation is arising, and because of which the law has become quite harsh, and probably it is losing its objectivity. Today, Dash Saab is here sitting with us. We should have the benefit of his presence. What is happening? I'll put the situation which is arising. Now, suppose the matter reaches before the appellate tribunal. The banker is a party there, the ED is party, and the borrower is also a party. Now, borrower somehow makes arrangement and says, ki, okay, after 1,000 crore, this 300 crore rupees worth property I have gathered, and I am ready to pay back to the banker. But the ED should allow the release of my bank accounts, because ED has attached all the bank accounts, and release my assets. I am ready to pay back rupees 300 crores immediately, and remaining amount I'll pay as and when I will receive. Now, ED will, in most of the cases, will take a very, very weird, action. It will, the ED stand, weird stand. The ED stand in most of the cases will be that since it is a tainted property, the right of attachment is with the ED, and it has been attached under Section 5. Only special court can release that attachment. So therefore, we deny, we do not give any such freedom. And so therefore, let the accounts remain attached. So on the one hand, the banker is suffering, because if the banker would not have approached ED, it could have easily recovered rupees 300 crores. Now the properties are languishing because of the attachment, and the borrower is also losing. Nobody is gaining. I do not understand what is the rationality behind it. Some amendment should be made, or some guidelines should come. This kind of situation should not arise. So friends, there are many more things which we can discuss. But today we have a powerful panel with us. Honorable Shri Darren Dash, Amit Khemkaji is there. So I think let us devote further time in the question answer session, because I am sure some questions must be there in your mind. Thank you very much for your keen participation. Yes, sir.
Thank you very much, Ashwin sir. Khemka sir, Rakesh sir, or Dash sir, would you like to add something before we take the questions? Or shall we take the questions, sir?
Pankaj bhai,
we should interact with the participants. That will be more helpful.
You know, after such a lucid and beautiful presentation, it is like, what else can we add? No, but I am very sure that our listeners, they must be having many questions, because Ashwini ji is very good at, invoking the thought process. He does it very well. So I'm very sure, and I can see many questions and in the question answer box also. So let's get on with those questions, I suppose. That would be fantastic.
Right. So generally, sir, what we do is I read out, because Ashwin sir has been talking for a long time, just to give a momentary relief to his throat. What I do is I read out the questions in loud for the benefit of other people, and then Ashwini sir or any one of you can answer. So I'll start with first question of Hariprasad ji. Sir, I think this question was mainly put when Dash ji was talking. So anyone can answer. Now the question is like this: whether several acts in numerous namesakes has achieved the purpose. or do you think there is a lack of coordination between the agencies? What is your suggestion to overcome this?
I think Dash sir can take up this question very well. And if the need be, then I will also pitch in. So I will request Dash sir to please take up this question.
Okay, I briefly, because I was the overviewer, as you correctly told. It was not possible to dwell at length on the issue, but I hinted. See, previously we had many laws which were dealing in some part of money laundering, but not as a whole. So, in the process, when it was found, the illicit transfer of funds from India came to several hundred billions per year. Despite the existence of the law, these laws, which are good laws, which are being implemented, but its efficacy on the ground level was not adequate to meet the menace. So a focused law was necessary. But it was more, besides this, it was the international pressure. It was the pressure of the world agencies, G7, FATF, that an integrated world financial system requires that a good economy should have a sound anti-money laundering regime. So, particularly since I was then in the ministry, I knew that it was under those pressures that these laws were drafted. And as you know, that is the reason why for a law which was adopted in 96-97 came to the statute book in 2002. It took so long a time and became effective in 2005. So it is not, there is nothing to find fault with numerous laws. It was the need of the time that required that, like all other countries, including even Pakistan has an anti-money laundering law, though it is under watch by FATF. So that is the reason. Everybody has to, and we had. That is how I would put it.
Ashwin sir, you want to add anything?
No, I think the objectivity is lost because of the poor implementation, not because of the law. Because the objective of the law is to nab the serious defaulters. But now, for example, in one case, what happened? A builder defaulted, right? A very big builder here in North India defaulted, made default to payments of banks. Then ED has made attachment of all its properties. All right, you attach the properties of the company. But the builder the builder has handed over some projects already, and the customers have purchased it. It's retail buyers. The customers have started occupying. Customers are living. Even those flats have been attached. What is the fun in that? Those flats, those properties, those plots belong to the customers, the retail buyers. So by doing such kind of action, the whole purpose is lost. So that is where the need of correction is arising probably. Rest everything, laws are good. They have got some purpose.
Ashwini ji, let me add something to it.
Yes, sir.
You know, there can't be any denial that the tough laws are required to curb the menace of the crime money coming into the mainstream. There cannot be any doubt about it.
Yes, sir.
Now, but the problem arises, look at another example. One example Ashwini ji has given. The other example is where a bank has filed a complaint for saying that the loan was taken fraudulently, and ED chips in, the CBI chips in, and then that whole property of the borrower is attached. Therefore, now the bank cannot recover its money.
Yes.
And the person, the businessman, has been sent inside. So the business has also come crashing down because the main person who was running the business, and by running the business, there was a hope that the bank might have got its money. But it has, look at the dampening effect on the whole business. It has made so many people unemployed. It has made the whole factory or whole business into a waste, and the bank cannot recover. The whole main complainant, the victim, cannot recover its own money because of the attachment made by the ED. So this has become, so somebody who is applying this law, somebody who is implementing, like Ashwini rightly said, that it is the implementation without applying any mind, and by using the powers using the powers in a draconian manner. That has become a main problem.
Very right.
Right.
So take up next question, sir.
Yes, sir. Sir, people are asking what is the difference between PMLA Act and PC Act?
Yes, Amit ji, please take up this question. Amit.
I think PC Act, you mean Prevention of Corruption Act, my friend?
Yes, yes.
The question is from Chilkamari Srinivas. I think, yes, sir, is that only.
I think that is Prevention of Corruption Act. Let me just explain it by giving an example. Yes. An officer of the government or the public servant takes a bribe. Now, taking the bribe and giving the gratification would be covered under the PC Act. That would be an offense under the Prevention of Corruption Act. However, utilizing that money for purchasing a property, that would be covered under the PML. Okay, that would be an offense under the Prevention of Money Laundering Act. So it becomes a proceeds of crime. The crime was taking money, illegal gratification, and utilizing it for the purpose of purchasing a property, or utilizing it for some other other apparently genuine purpose, or washing its color, or laundering it, would be covered under the PML. So that is they go hand in hand. In fact, Dayaji was saying that it is dependent, the PMLA is dependent on the other act or other crime. So I would say that it is a parasitic law. Or it is a symbiotic law, you can say.
I'm just moving to next question from Mohit Gupta. Can PMLA be invoked without conviction of the scheduled offense under the schedule? The question is like this: can PMLA be invoked without the conviction of scheduled offense?
Look, now the question can be put in another way. Whether it can be invoked, the answer would be yes. But whether ultimately a person can be held guilty of offense of money laundering without he being convicted for the scheduled offense, that is the piggybacking law, that is the original offense. Because as Amitji said, that this law is piggybacking upon other law. So first of all, there has to be scheduled offense. Only then offense of money laundering will come into picture. So my understanding of the subject is that a person has to be convicted of the offense of scheduled offense. Unless a person is convicted of the scheduled offense, he cannot be in the air convicted of any other offense. No. But the situation is because of some amendment in section 44, which has been made recently, some kind of different interpretations people are saying are coming up. But the issue has become gray, but still my understanding is the understanding is not correct. My understanding is that there has to be, first of all, commission of scheduled offense. Unless the scheduled offense is committed, a person cannot be alleged to have committed offense of money laundering. That is my understanding is. But this is since a very, very controversial, debatable area. If Amitji would like to clarify or add it, I think that will be very welcome exercise.
Yeah, but before that, I think he has completed the question at a later point of time because he just continued the question as again whether only on accusation of scheduled offense can invoke PMLA, that too without any conviction of scheduled offense.
Yeah,
what happened?
That can be done. That can be done. But the issue of section 44, which has been now amended with an explanation, as Ashwini ji was saying, the explanation says that the proceedings before for prosecution of PMLA offense will not be dependent upon any order made in the trial of the scheduled offense. So if I try to harmonize it, actually it looks, on the face of it, it looks very odd that how if a person has been acquitted in the scheduled offense, then how can the offense of money laundering survive? But if I try to harmonize it, and that I was discussing with Ashwini ji, then let me just give you an example. Suppose a theft has taken place. The jewelry of A was stolen and B was caught for it. And it was a jeweler who had taken that jewelry and had converted it into money. Now this jeweler has dealt with, apparently the jewelry is of A, it was found in the hand of C, so it is a stolen property. It is another thing that B, there may not be sufficient proof or sufficient evidence in the scheduled offense which is being tried against B that to convict him, or the investigation or the prosecution or the trial may not be very diligently done by police. So that should not affect the prosecution of C, the jeweler, who has actually changed the color of this stolen property. So that is probably the intention, but the law has still to develop. It has only been amended few months ago. So we will see how the courts interpret it. We lawyers will interpret it the defense lawyers will interpret it for the benefit of our clients. But let's see how the courts interpret it and how the ED comes out with whatever explanation they want to come out.
Thank you, sir.
Can I
Yes,
add
sir,
a little?
please.
Yes, this gentleman, the question is really, he wants a very simple thing. Whether this can be invoked? Yes, it can be invoked when a mere FIR is filed, but under the second proviso to section 5, even without an FIR, the director can invoke the provisions of attachment provisions of the provisional attachment provisions of money laundering law, even without a scheduled offense FIR being filed. So that is the trick. There is no need for him to, the director of enforcement does not have to see that there is an FIR, that is a scheduled offense. He has to only issue a satisfaction note that if he does not attach this property, the object under this act will be defeated, and he can provisionally attach it. So that gives him a leeway. But underlying cause, satisfaction, he would always refer to some criminal offense. But there was no need, technical need, for filing of a FIR or charge. That's it.
Thank you, sir. I'm just moving to the next question, sir. Will the use of cryptocurrency for money laundering be covered under PMLA in view that this is not a legally acceptable currency?
Yes, sir. Since now RBI has probably declared that the use of currency is an offense. So since it is an offense, but it is, Amit ji, what would you like to say? But it has not been made part of the scheduled offense. So since,
see,
yes, sir.
Cryptocurrency need not be a scheduled offense. Basically, cryptocurrency is an asset. If some scheduled offense is committed, or money laundering is committed in acquiring these assets, then it can certainly be attached. See, the question is, will the use of cryptocurrency for money laundering, if he is using cryptocurrency for laundering money like any other asset, it like a shopping mall or a house or a money or something, then certainly it will come under the provisions of a PML.
Sir, probably
Then-
Mohitji's question, I mean the viewer's question probably is
Then
dealing
the
simply.
question is drafted a little, there is ambiguity on this, but basically whether it is legally acceptable currency or not, any asset that is involved prima facie in money laundering is attachable.
I think, sir, here we need to see something more. If it is a part of any proceeds of crime, then of course, like any other currency, it will be covered. But the question is, if a person is dealing in the cryptocurrency simpliciter, not involving any other offense, whether that dealing itself can be roped into the activity of money laundering. So, Amitji, if I remember, to the extent I remember, this has not been yet made part of the scheduled offense. Though dealing in currency is an offense, but not a scheduled offense. But somewhere in IPC section it will be covered, and from there I think it will be covered in scheduled offense.
Ashwini, what I remember recently, there was a Supreme Court decision in which, dealing in cryptocurrency, RBI circular has been upturned. So,
From that angle, yes. So then it will not be. But to say of scheduled offense, it will not be offense itself.
It is not even an offense, yes.
It is not an offense. No, but that was in some other context. That is not full upturning of that. That is where some mobile operators were using it for the similar purpose. So they have said probably to that extent it is not an offense. But it is not that the entire thing has been made legalized. So it is not that if person is dealing in virtual currency, then it is a fully legal exercise. So I mean, before we give any go ahead on this, we need to check.
No, but I do remember that the Supreme Court had said that the RBI was not competent to have issued that circular, which held this trade in cryptocurrencies illegal. So when the very basic and genesis edifice has gone, now that needs to be examined.
Yeah. Because they have not said they did not have competence at all. They said for that particular transaction, they were actually probably dealing in some mobile app. So probably they said for that mobile app, they had no authority. They have not said that RBI cannot stop a person from creating a new virtual currency and start dealing it as currency. No, probably to the extent I remember, they have said to this extent only. So I think let's read it properly and then come back on this. We have 2 days still to go.
Yeah, we'll take it as question number 1 on Saturday, sir.
Yeah, taking it to be, if the question is the dealing simpliciter in cryptocurrency, yes. Even if it is an offense, till it is a scheduled offense, PMLA will not be attracted unless there is some other offense which is a scheduled offense. If there is some other relatable offense, for example, Section 51 of Black Money Act, or some kind of a forgery or some kind of a cheating, something has to be there in order for this to come to attract the PMLA, I suppose.
So I'm just going to the next question. Before the authorities summons, proceeds of the crime are given as gift to minor child or donated to charity. Can it still be confiscated from minor child or charitable institution?
What is the question? Let me read the question also, sir. Before
Anand Sharma at 7:23 p.m. Sir. Again, I am reading. Before authorities summon, proceeds of the crime are given as gift to the minor child or they are donated to charity. Can it still be confiscated, taking it from minor child or the charitable institution?
Now, proceeds of crime are proceeds of crime. If a bona fide purchaser obtains a property by way of valued consideration, then there could be some saving under the law. But if it is given by way of gift only, I don't think it will lose the character of being pursuits of crime. They are very much available to the authorities for being attached or confiscated as pursuits of crime. So in this manner, I don't think they will be able to do away the rigors of law in this case.
Das, sir.
Yes, sir.
Das, sir, will you like
That,
to?
that is correct. It does not change character. It will remain proceeds of a crime wherever it goes. And coming back to that question, cryptocurrency is illegal in India. That Supreme Court judgment is valid, and cryptocurrency is legal in India. So dealing primarily in cryptocurrency will not have any problem.
Sir,
That is.
we are talking about the Internet and Mobile Association of India versus Reserve Bank of India case, which is dated in writ petition number 528 of 2018, authored by Honorable Justice V. Subramaniam. Probably that judgment is the only judgment,
Yes.
which 180 pages judgment. And so, sir, your understanding is that they have declared it as legal.
Yes, yes.
So let's do one thing. Very interesting question. Let's all read it, and maybe when the panel discussion starts.
We are coming back tomorrow, day after, we'll help it. But very quickly, I made a search and I have found that they have started dealing in cryptocurrency. Crypto exchange CEOs are active now.
But sir, the way there was a mushroom growth of the companies who are dealing in virtual currencies earlier, now they have they are not back into business. So something is still stopping.
But who is in business these days? All the business has stopped.
No, I mean even before lockdown, I mean they are not back into business. So I think I don't know whether viewers are aware about that or not. On day after tomorrow, after the Amit Khemkaji session, we are having a panel discussion in which Dr. Rakesh Gupta would be there, Amit Khemkaji would be there, Dash Saab would be there, I would be there, Dr. Raj Agarwal would be there. So we invite questions from the viewers on any subject, whether it is tax, international tax, income tax, search and seizure, any economic law like PMLA, Benami law, anything. It is
Anything.
question answer session. So in that panel, I think first question we will start with this virtual currency.
Great, sir.
Yes, sir.
The next question, basically, I had to request you, which our Kashish sir is doing it. Sir, generally when the whatever slides you are presented, we request you to share with us so that we put it on our website, sir.
Yes,
So,
sir. Yesterday's slide also and today's slides also we
Yes,
will send to you. You can
Sir, I'll first take up question from Ganesh Balakrishnan. Conviction of scheduled offense. But in India, this is a long drawn process. And how much PMLA has been effective? I have not seen many convictions. Ganesh Balakrishnan is a very senior chartered accountant and a very learned speaker from Deloitte, sir. He works with PR Ramesh, sir.
First of all, thank you, Ganeshji, for participation in this session. The question which rather the government should see, on the one hand, they are becoming so harsh, the implementing agencies are so harsh. On the other hand, they are not able to achieve. And it is mainly because of the reason that the energies are scattered. Energy should be into the right channel, not in misimplementing and wrongly enforcing the law. Probably Dashta from his experience can say something more.
No, I had dwelt on this while I was speaking. Though the law is in the statute book for such a long time now, we can't say that 2002 law effective from 15 years in operation. It has till end of March 2018, only 451 prosecution complaints were filed. That is not being a very effective implementation, I would say. With this kind of a parallel we are having in India, money laundering is taking place under the nose of every time proceeds of a crime is floating around, and conviction is only 20 by today. So it does not speak well of the anti-money laundering regime or its efficacy. I agree with Mr. Ganesh Balakrishnan. He got to the core of the point. You see, ED is gloating that we have seized so many things. What it has seized? It has seized most of the bank money. So, and what has happened? Now, the money that the proceeds of a crime in the Nirav Modi case, what has come? It will be confiscated. Even PNB will not get a morsel of it. So it is all skewed. In fact, only when the Supreme Court or High Court will come and take a view on these aspects, then something will probably come. The core aspects of money laundering is missed in the anxiety to attach more and more property, but real convictions, real confiscations are one thing. That is how it is on the ground level.
Yes, sir. Next, please.
Shall I go to next question, sir?
Yes, sir.
Next question I'll take from Gokul Vadapalli. Sir, how is the law being implemented elsewhere in the world, just to understand why we find ourselves in the position we are in spite of the law in place?
See, the law is very robust in USA. They have altogether 9 laws, and they started in 1976 from Banking Secrets Act. Money Laundering Act came about in 1980s, much before we had our law. It is mature, robust. UK has Proceeds of a Crime Act. Now they had also another Money Laundering Act. But despite all these acts, despite the fact that it is very effectively done and the big players are fined in billions of dollars, banks and everybody, but all said and done, London is considered money laundering capital of the world. New York, when the recession started in 2008, New York had the problem that there was no money in New York. They closed their eyes and all the crime money, drug money was invested in the real estate, and it started booming by 2013. When Mike Bloomberg was the mayor, and they had, even having such robust law, they closed their eyes and did it. So to boost their economy, they can do also what they have done. So merely having a legal framework is not the end all and be all and end all. What is required is the will to implement it properly. Our major problem is not bank default, probably corrupt. But what is more important is illicit outflow by way of imports and exports. And who knows more than chartered accountant community? So basically what I want to emphasize that yes, everywhere in the world, they are going after money laundering. They are going after beneficial ownership registries. Even in Canada, in British Columbia, they are now going after each company and each land pieces to find out who is the owner and why it is. It has happened probably this year. Yes, this year. So many countries are going for this and very, very effective about this. But despite this, the drug money, the mafia money, the dirty money is flourishing, and it will be a constant battle. And we cannot lose this battle. We have to fight it. We have to make our law stronger and make whatever flaws are there in its implementation, we have to plug that loop.
Yes, sir. Take up next question, please.
Sir, Ashwin sir, just wanted to remind you for all the panelists, in fact, there are 8 to 9 more questions and it's already, we have crossed 8, it's 8:07. Shall we take up or shall we just keep the questions for the Saturday panel discussion, sir? Because
okay, we can conclude it, but I will give one answer to probably that answer will cover all the questions.
Oh, great, sir.
Many viewers are asking whether it will be covered under PMLA or not. Look, there are two things. Either the offense is directly covered, then it comes under scheduled offense. Or the commission of offense is such that it is punishable in under one of the IPC sections like forgery, like theft, like cheating, etc. Now, for example, you are saying GST violation or tax violation, income tax violation. So as I said, tax violation is not directly covered. But in that process, if some other indirect violations are being done, then kindly remain aware of the fact that indirectly it can be covered. So that is how probably the things, we can summarize if you don't want to take any more questions. But if still some questions are asked, Pankaj, if you can make a note of that.
Yeah, we will note of all the questions, sir, and then we will
yes,
during the Q&A time. And even if on that day, if you are unable to ask, then I'll trouble you once more by sending a mail of all the questions to you, and then we'll forward it.
No, what we will do that day, that we will start with our panel discussion with the questions which are left out from that day.
Yes, sir. Yes, sir. Yes, sir. Great. Yes.
So sweet of him. So sweet.
Thank you very much, sir. Before I will first say I'm very grateful to R&D sir, Amit Khemka ji, Rakesh ji, and also Ashwini sir for bringing some excellent sessions to us. But I think our every closing, Dasha, I was very angry with Banu for not introducing you properly. So at least I want him to close the session properly. So thank you very much to all of you and participants. But I want Banu to have a proper closure. Banu, unmute. Banu, unmute. Banu, unmute. Right.
Suniji, after listening to you and the learned panelists these 2 days, most of the gray areas in our brains to a great extent have been laundered. We are that much more cleaner in our thoughts. And listening to this, sir, as a layman, forgetting that I am a chartered accountant or that we are a group of intellectuals, as a layman, I am reminded of the popular message-oriented song from the film Tisri Kasam. Sajan re jhoot mat bolo. भला कीजिए भला होगा, बुरा कीजिए बुरा होगा, बही लिख लिख के क्या होगा, बही लिख लिख के क्या होगा, यहाँ सब कुछ चुकाना है, सजन रे झूठ मत बोलो, खुदा के पास जाना है, न जेट प्लेन है न बेंच कार है, वहाँ पैदल ही जाना है। सर ओ सर, चलते चलते आप एक वादा करना पड़ेगा, जब भी हम बुलाए आपको आना पड़ेगा। We want you to participate in webinars and seminars organized by our Hyderabad branch and enrich us by sharing your knowledge at frequent intervals. Now the challenge, the ball is in the chairman's court. Saab se to wada le liye. Sir has been silent. Sir, one more thing. Apart from sharing your slideshows, I would request you to share your two photographs with the beautiful backgrounds. Yesterday it was mountains and greenery, and it was so pleasing. And today the heart is filled with the whites and the grays, the background, beautiful background, sir. So along with the slides, we want the background also to be shared so that it will really inspire us. We have been sitting against the backdrop, boring backdrop of walls or some panels, but your backdrops have been excellent, sir. Your taste is good. Hats off to you, and namaskar to all the panelists. We are looking forward to hear from you tomorrow and day after also. And thank you very much for the words of wisdom. Thank you, Chairman, for giving me the opportunity.
Thank you.
Thank you very much, sir. Thank you. I'll end the meeting, so if you can.